said and talked about so learnedly on this matter, nobody has ever covered the subject of sovereignty, which is really at the core of the original intention to take back control. And I am therefore concerned today that the public may be asked to have an opinion on this.
My noble friend, we've had a very long period of what some people have called filibustering, which resulted in a deal between the front benches when the opposition leader gave an undertaking not to use the guillotine or to use this procedure again. We respected that. We agreed that this bill would be given safe passage with speed through the House. Would my noble friend not think that it might be more sensible to withdraw his amendment and allow us to proceed with what both sides of the House have agreed to do?
I entirely recognise that fact. My concern, as I'm sure the noble lord will share with me, is for the understanding of the British public when it comes to the point where they have to accept whatever is the final decision. And I do not believe that they have enough knowledge of the reality of what stands behind the agreements that they have to choose between. And that is why I worded it today, to take in about the only way I could bring this into a discussion today. And I thank the noble lords for their comments on that. Now,
and then you will beg leave to withdraw.
I will beg leave to withdraw, but I will also at the same time please counter that with an urgent plea to all concerned with this to get the British public better informed, please. They're not.
Is it your lordship's pleasure that this amendment be withdrawn? Amendment by leave withdrawn. The question is that clause 2 stand part of the bill. As many of that opinion will say content. The contrary not content, the contents have it. In clause 3, amendment 2, Baroness Deach.
My Lords, this is a straightforward technical amendment to plug a gap which I noticed as soon as the bill was published, and indeed referred to it in my speech on it. As we know, this bill mandates the Prime Minister to seek an extension to the withdrawal date provided for in Article 50 in the form of the letter in the schedule. It goes beyond the earlier withdrawal bill, known as the Cooper-Letwin Bill of April. That bill required the Prime Minister of the day to seek, but not necessarily to achieve, an agreement about extension. Mrs. May could have picked up the phone, asked Monsieur Barnier for an extension, and then said that on reflection she didn't want it. Of course, that is not what happened. That loophole is closed in this bill in clause 3, subclauses 1 to 3. Subclause 1 says that if the European Union agrees an extension to the 31st of January next, the Prime Minister must immediately agree to the proposed extension without qualification or consultation. But subclause 2 says that if a date other than the 31st of January is offered, the Prime Minister may not have to agree, because subclause 3 says that if the Commons decided to disapprove the extension offer, the UK does not have to agree it. I do not know why the two are treated differently. I note that the Commons is given this opportunity to consider the offer if an extension is granted which is not the 31st of January. It could be the 30th of January or December next. But if the extension is the 31st of January, this is what might occur. Suppose the European Union agrees to an extension to the 31st of January, but attaches a condition. For example, the holding of a second referendum, or a payment of billions, or settling issues to do with migration, or even a new Prime Minister. The Prime Minister has to accept it immediately, as set out in line 4 on page 3. No consultation, no Commons approval, unlike the provision in subclause 2. My amendment adds to the arrangement contemplated in subclause 1 the same requirement that the Commons should have 2 days to consider and accept or reject any condition attached. That must be right. I imagine this difference was an oversight unless the proponents can explain the discrepancy. I also note, but have not attempted to amend, a difficulty with the meaning of 2 days in subclause 2 and 2 calendar days in subclause 3. They are different. Why? Imagine that the European Union offers an extension which is not to the 31st of January and is offered in early October, or some period when Parliament is not sitting. Is Parliament to be summoned to agree the question, or does 2 days mean 2 sitting days, indeed Lord's sitting days, whatever they are, as set out in Clause 1? Might Parliament be prorogued in order to sidestep these time provisions? It is not clear. But what is clear is that the Commons should have some power for 2 days to scrutinise and approve any offer of an extension to 31st January in exactly the same way as it is empowered so to do if the date were to be the 1st of February. That is the purpose of my amendment. My Lords, I beg to move.
Amendment proposed, page 3, line 6. At the end, insert the words as printed on the Marshall list.
The point that I have just made in the previous debate, in the hope that the government will respond. The government is going to have to respond to the Baroness's amendment, at least I hope it is. Subsection 1 of section 3 of the bill is premised on the basis that the European Council decides to agree an extension. Now, so long as the United Kingdom is a member of the European Union, and in respect of a unanimous decision, it is at least in theory possible for the United Kingdom to oppose the extension, despite the fact that it has applied for one. I do seek an assurance from the government that the government will not seek to oppose an extension for which it has applied.
Him is on this amendment to speak to it. The second reading yesterday was a fascinating debate with much history covered, as is appropriate for a second reading. There was some wide discussions of very well rehearsed arguments, often very eloquently expressed. Like many of your noble lords here today, I had the, I won't quite say pleasure, of listening to the debate on the business motion the preceding day, which went on till 1:30 in the morning. I can only admire and respect those members of this House who, having left at the same time as me at 1:30 a.m., came back to the House on the same morning with such powerful and well-written speeches on a bill which itself had only arrived a few hours earlier. The speeches at the second reading were, of course, political, but at committee stage, we come to the business part. This is the time when this House should really come into our own, looking at the detail of the legislation and offering suggestions to the wording which might have been missed out in the other place. Although second reading did contain some excellent and thoughtful points, today is the time when we, as a House, might take a cold and calm look away from the politics and really perhaps add some value to the bill in front of us today. I recall that yesterday Lord Hannay of Chiswick specifically said that the bill is a rather skillfully drafted bill. Maybe. I'm sure it was done by those with vast experience in such matters, but it was prepared in a huge rush, and I understand that one amendment from Mr. Stephen Kinnock was included by accident. As I've suggested, there was an almost indecent hurry between the bill arriving here and the second reading, and so it's more than understandable that noble lords didn't have the full opportunity to reflect on the actual wording and meaning of the bill line by line, as Baroness Deach has said. There were, of course, exceptions, and I'd like to highlight Lord Mackay of Clashfern's remarks. It wasn't his wonderful sentence, which I'll try and remember every time I'm in a debate here on in, where he said, "I wanted to speak near the end so I could hear the wisdom of others rather than my own." I wanted to pick up on his observation that this bill seems, in Clause 1, to identify the reason for the extension. I quote from the bill: "The Prime Minister must seek to obtain from the European Council an extension in order to debate and pass a bill to implement the agreement between the UK and the EU under Article 52 of the Treaty on the European Union, including provisions reflecting the outcome of party talks." Now, to declare my interests, although I voted leave, I did publicly support the agreement to which he refers, both in debates in this House and print in a national newspaper. I'm not sure in retrospect that I was right, but I did. even if people like me would be happy now that the agreement is one we still want, what happens if it's not the one we're offered by the EU, as Baroness Deach has said, because terms are attached to the agreement of the extension? So the reason this amendment has been suggested is that it's entirely possible the EU will only grant an extension which contains new conditions, and not in that agreement or not currently on the table. And as I understand it, the Prime Minister would have to agree these new conditions, and this was not the intention of the bill as it appears to be drafted. Some of these terms might be acceptable and attractive. I want to put on the record to the House that I went to Brussels to meet Monsieur Barnier as part of the all-party parliamentary emergency task force led by Alberto Costa MP, to try and persuade Mr Barnier to give citizens of the UK rights in the EU and citizens in the EU rights in the UK immediately. We had a friendly meeting for over an hour, and he clearly understood the points made by the representatives of both houses and indeed the representatives of the citizens concerned, but he refused to budge an inch. The EU can dig in when it wants to, as indeed we can. For the record, he has agreed to meet us again in October. If he does acquiesce to our requests, that would be extremely helpful, but there may be other requirements the EU would make, particularly perhaps financial, which none of us would find acceptable. We have to reserve the right for Parliament to review these in the usual way. Accordingly, it seems only fair and right that such changes should be approved by Parliament rather under this bill, and this is the purpose of this amendment. Of course, the bill has to go through the House, but it is entirely appropriate that it carries amendments which your Lordships feel are appropriate.
I don't wish to detain the House, but I do think that I do support Baroness Deach's amendment. I do think that she has spotted a loophole in the bill. I'm very surprised at my noble friend, Viscount Hailsham, asking for responses from the government. This is a private bill. This is a piece of private legislation. And like a lot of private bills, it is...
I'm surprised the noble lord has expressed surprise. We have private members' bills going through this House on a frequent basis, to which the government front bench is not only present, it actually responds normally to every amendment. He would, I'm sure, agree. He disagrees with it, but this is one of the most important pieces of legislation this House has considered in the last year, and for the government to actually refuse to answer any questions or make any response, I think is an abuse of this House.
To get us back into the territory we were in earlier this week. So he'll forgive me if I don't actually respond on the abuse of this House person, given that this bill itself has arisen from an abuse of the procedures in the other place. I'm genuinely concerned that we should pass a bill which people do not realise the implications of. And I have to say, until this morning, I've had no contact with Baroness Deach. Until I read her amendment and read the bill this morning, I had not realised there was a real problem here. And I was simply making the point that private members' legislation, without the benefit of the drafting and the backup of the government machine, is often defective, and it's one of the things that this House does, which is to point these out and to make the thing.
Would my noble friend give
in a second,
yes,
and to make the bill sensible and possible to be carried forward. I did understand, and here perhaps I'm agreeing with the noble lord in his intervention. I do understand that where the government has a particular interest in the bill, it would be perfectly appropriate for ministers to respond. But it's certainly not right to ask ministers to comment on the drafting of the bill and the nature of the bill over which they have no responsibility. I agree with you.
I'm very grateful to my noble friend, but would he accept that the question that my noble friend, the Baroness Mackintosh, posed yesterday doesn't relate to drafting? It relates to policy. And as a matter of policy, this House is entitled, the country is entitled to know that the government will not seek to oppose an extension which it has thought That is a straightforward question to which Parliament is entitled to a clear and straightforward answer.
And it would be a very good question to ask in second reading or third reading, but we are at committee stage here and we are discussing a particular amendment.
Would my noble friend give way?
No, not
it was asked in second reading.
Well, and indeed we're aware of that because my noble friend told us that not 10 minutes ago. What we are discussing here is Baroness Deitch's amendment, where she has made a perfectly good point about the drafting of the bill. And I very much hope that the noble Lord in charge of this private bill will be able to address that point. Now, the second point I was going to make, which was in support of the intervention made by the noble Lord, is that I understood that the amendment to the bill, which was made by Mr. Kinnock in the other place, was considered deficient and defective and was passed because the government by mistake refused to put in tellers. But I don't see an amendment on the order paper in order to correct this, and I would like to hear from the Chief Whip what the position is on that at some stage during these proceedings. But as we are concerned with Baroness Deitch's amendment at the moment, I very much hope that the noble Lord, Lord Rooker, will be able to explain why she's wrong, because my experience is that she's a very clever and informed lawyer or barrister, and she's very seldom wrong. And if she's right, then this is a real problem with this bill.
My Lords, I rise in the hope that some EU constitutional law expert may assist me. My understanding was that until the end of the Article 50 period, we remained a full member of the European Union with all the rights and obligations of such a member, except in such instances as we had voluntarily decided not to exercise such rights. Therefore, an extension to the Article 50 period would be an extension of our period as a full member of the European Union. Any such extension which was offered with some sort of reduction in those rights would therefore, it seems to me, not be an extension of the Article 50 period, but something else entirely. Have I misunderstood?
Yes. Well, if I may speak very briefly in support of the Noble Baroness's amendment. The Noble Baroness is clearly right, and I hope that will be accepted around the House. The drafting of the bill treats the European Council's response to the request for an extension as if it might take one of two forms. But in fact, the position is not binary. There are three possibilities. The first possibility is that the Council will unconditionally agree to the extension. In that case, pursuant to the bill, the Prime Minister is bound to accept that. The second possibility, which is different, is that the Council might agree to the extension to the end of January, subject to terms, subject to conditions, which may or may not be acceptable to the government or to the people. That is not an unconditional agreement. That is a counter-offer. And as a matter of law, a counter-offer destroys the initial offer, which no longer remains open for acceptance, and is a new offer, which either can be accepted or not. It is that possibility that has been overlooked by the bill as presently drafted. That is why the Noble Baroness's amendment is plainly right. The third possibility is that the Council will make a different type of counter-offer, which is to propose an extension which ends on a different date. That is a separate type of counter-offer, and that, as the bill is presently drafted, triggers the provision at subsection 3. The Noble Baroness's point, as I understand it, is that the second type of counter-offer should also fall within the scope of subsection 3. Exactly. She is plainly correct.
Thank you.
My Lords, well said. I also would like to add my support to the amendment in the name of the Noble Baroness Lady Deitch, who has set out very clearly why the bill is clearly defective. I think it happens to be a terrible bill, and all it will achieve, if passed, will be to kick the can further down the road, which has a huge cost in terms of prolonged uncertainty and putting off decisions to make new investment. As my noble friend who has just spoken has pointed out, there are different possibilities as to how the European Union will react and respond to a request for an extension. Noble Lords will remember what happened at the last request for extension, There was a very long debate in Council with President Macron seeking to allow us a much shorter extension, whereas some other member states wanted to offer a very much longer extension, and the 31st October was a kind of compromise date. Also, there was much talk in the Council as to what other conditions should be applied to any acceptance of a request for an extension. And this is the reason for the Noble Baroness's amendment. It's not just on that point that the bill is defective. I'd like to know what is a Lord's sitting day, because we have in the bill, in 2 instances, something called a Lord's sitting day, which I've never heard defined before. We have calendar days and we have days. So it's a little bit poorly drafted, and I have always understood, my lords, that the role of your lordship's house is to scrutinise and improve deficient legislation. I also would like to ask whether I think I'm asking the noble Lord Rooker, because he's introduced this bill. Clause 3, subsection 2, refers to what happens if the House of Commons has decided not to pass a motion between 2 calendar days. It does not say what happens if the House of Commons has not decided to pass or not decided not to pass a motion within 2 calendar days. If the decision, and my lord, should this have an uppercase D, is it intended to signify a formal decision of the Council, in which case it should have an uppercase D? If the decision is made on a Friday, or indeed on a Thursday when the other place is not sitting on the 2 subsequent calendar days, it is quite likely that the other place will not have had an opportunity to decide whether or not to pass such a motion. So I believe that, quite apart from the very harmful effect of this bill on our country and on the current negotiations with the European Union, I think that the least your lordship's house could do would be to support the noble Baroness in doing something to mitigate the harmful effect of this bill by making it a little bit clearer.
I rather echo the puzzlement of the noble Lord Stirrup, and would like to ask Baroness Deach or other sponsors of Amendment 2 to explain where in Article 50 the EU 27 gives the EU 27 any power to impose conditions, because as I read Article 50, paragraph 3 just says that the treaties shall cease to apply to the member state, UK, in case point, at the end of the 2-year period or at the end of the extended period. So I wonder if she could explain to me what is the basis in EU law for believing that the EU 27 have the power to impose any conditions.
Before the noble lady sits down, could she, she's vastly experienced, she understands, having been in the European Parliament. I can't pretend to, but last time round when this was being discussed, I recall that President Macron and others, when the issue of the extension beyond the 31st of March was being discussed, I recall that he was intent on imposing all kinds of conditions. Is she saying that when he was saying that, he was not aware of the nature of the Article 50 process or European law?
Well, I obviously have no idea what went on in the private office of President Macron, but as you know, there are loads of lawyers in Brussels. The legal services of the 3 institutions are very distinguished, and I could imagine that there could have been some lively discussion between the politicians and the lawyers as to what was possible. I must I acknowledge that I'm not aware exactly what could have been the content of those discussions, but I remain in my and I make no pretence to be an EU lawyer, I myself still remain untutored as to what the power would be, just on any reading of Article 50, to impose those conditions. And since Baroness Deitch has put forward the amendment, and I see Baroness Faulkner eager to come in because it's perhaps also relevant to Amendment 3, where that power comes from.
Assist the Noble Lord Stirrup and the Noble Lady Baroness Faulkner, because this is very much the subject of my amendment, which if the House would be willing to hear from me now, would not need to be moved later. The European Council on December the 11th, on April the 11th, 2019, in response to Mrs. May's request for an extension of Article 50, made a decision. Its concluding statement took the form of a decision. A decision, as I understand it, and I've just returned from Brussels yesterday. I would have spoken in the debate yesterday, but I was unable to because I missed the beginning. But what I was told in Brussels yesterday was that the decision of the European Council of 11th of April 2019 does stand as law. That European Council took note of the duty of sincere cooperation. The duty of sincere cooperation exists in all treaties, and the United Kingdom has been bound by it. But in particular, it referred to the conduct of the UK as it applied to its relations with the EU as a withdrawing member state. Moreover, it added a further caveat in that decision, and I quote, "To this effect, the United Kingdom shall facilitate the achievement of the Union's tasks and shall refrain from any measure which would jeopardise the attainment of the Union's objectives, in particular when participating in the decision-making processes of the Union." What provoked me to try and intervene yesterday was that this is a clear curtailment of the decision-making process of the Union. And I think it was Lord Kerr, as Baroness Ludford has just asserted, that the United Kingdom retains all rights. It does not retain all rights, because that decision of the European Council on the 11th of April, in granting the extension, imposed a new condition to say that the attainments of the Europeans' objectives in particular, which was not defined in law, when participating, the United Kingdom has to exercise restraint and refrain. The word is refrain, my lords. The United Kingdom shall refrain from jeopardising the attainment of the Union's objectives in the decision-making process of the Union. I raise this question because I would be extremely grateful if Lord Rooker, when in conclusion on this amendment, and I've indicated to the House I won't be moving my own amendment if he gives me that response, if he can explain to the House that if the extension, and in Brussels I heard that the extension, if it was liable to be offered for long enough to the UK to either change a government, have a new referendum, give it the time to have the new referendum, and then come back, renegotiate, or whatever the Labour Party wishes to do. So that what I heard in Brussels yesterday was the United Kingdom was likely to get a very long extension. Now, I wonder if Lord Rooker would be able to explain to the House that if the extension, let's say, goes up to December 2020, December 2020, then given that the European Parliament has not engaged with any of this House's select committees, European Union select committees, since the triggering of Article 50, which was March 2017, given that there is no access to the Commission in a new Commission and a new work programme, in a very activist new work programme, and given that we are not allowed to jeopardise the Union's objectives, of which we have some idea but do not know because the new Commission itself is not appointed, would that not imperil the United Kingdom's interests for a period, in reality, from when the Parliament and its committees stopped engaging with us, but at least, even now, if you want to take the minimalist view of this, from March 29th, 2019, when the United Kingdom was due to withdraw and when this condition started applying. This is a new condition, and it applies from the 11th of April 2019. The United Kingdom could potentially be in a position where its interests
would not be adequately safeguarded or represented for 18 months or so.
That we have today is that we are constrained on time, and that is the fault entirely of the government for deciding that prorogation should take place next week, and therefore we are in something of a constraint. We owe a great deal to my noble friend, the Chief Whip, and the noble lady, the Leader of the Opposition, and those who reached a sensible compromise solution in the early hours of Thursday morning, and we're grateful to them. They say to us, and I accept that we need to conclude the proceedings on this bill today, and it's because of the prorogation announcement, the prorogation guillotine, announced by the Prime Minister 2 weeks after he decided to do it, and we know that from the depositions in the Scottish court. But we also know, and I regret the fact that there is no minister here to reply to the debates. It is frankly an insult to the House. And I deeply regret it. But when he was here yesterday, my noble friend Lord Callanan made it quite plain that he knew that our European friends and neighbours would accept 2 things, because it was very clear. One was the revocation of Article 50. Clearly that will not happen. I don't want that to happen. But he also made it plain that the deal that was on the table, Prime Minister May's deal, was still possible. He also made the point that he had enthusiastically promoted that, as indeed he had. And all members of, let me correct myself, most members of Mrs. May's government did promote it valiantly. And my lords, I believe, and we now have the opportunity under this bill, imperfectly drafted as I acknowledge it is, we now have the opportunity with the Kinnock Amendment to bring that back and enable this Parliament to make a decision on 4th vote on the Theresa May deal. And I'm bound to say, my lords, I believe it would be a service to the country to do that. It would be the, as I said yesterday, it's only the beginning of the beginning, because there are many, many more rounds of negotiation to take place. But at least, in a moment, certainly. But it would at least mean that we had something that had been supported by the present Prime Minister in the 3rd vote, supported by Mr. Rees-Mogg in the 3rd vote. So clearly they believed it was the right thing to do at that particular time, and I wish we could now get on and do it. Of course I give way.
To my noble friend, and I entirely agree with him on the subject of getting on with discussing these amendments and the nature of the amendments. But is he seriously arguing that if a problem which affects our national interest arises from the drafting of the bill, that we should just ignore it and allow it to go forward? I mean, it's perfectly possible for the sponsors of this bill to agree the amendment, for it to go to the House of Commons and for it to come back and for it all to be covered by prorogation, particularly as both front benches have agreed to take whatever measures are necessary to try and expedite the bill. It's perfectly possible. Surely we need to address the point which Baroness Deach and other members of the House have identified. And all this repetition of all the arguments that we've already had for the last 3 years is frankly a waste of time. We are at the final point now, and we need to put on the statute book this bill, but in a way which actually makes sense. And we can't, as a House, say, well, we're just going to pass imperfect legislation because the government were responsible for prorogation.
That was a fairly lengthy intervention, but the fact of the matter is that we have been placed in a straitjacket by the government's decision on prorogation. We have an agreement between the 2 front benches here, and that is why we should move forward and get this bill onto the statute books as quickly as possible.
Hadn't intended to follow up on Lord my note. I hadn't intended to follow my noble and gallant friend Lord Stirrup's remark, because he included in them an invitation to some EU constitutional expert. And I absolutely do not aspire to the status of an EU constitutional expert. But what he said was, in my view, absolutely correct. There are two possible statuses. One is the status of a member of the European Union. One is the status of a former member of the European Union. Baroness Ludgrove is absolutely right. There is in Article 50 no provision for qualitative conditions on an extension. Temporal conditions, the length of the extension, that is possible. And that's what we're talking about. The point raised by Baroness Faulkner of Margravine about the European Council decision refers to the treaty rights and responsibilities of a member. One of them is the duty of loyal cooperation. That is set out in the treaty. It would be not possible to withdraw treaty rights by European Council decision. The only way you can change treaty rights is by amending a treaty which requires unanimity, and while we are members, we would not, presumably, vote to limit our treaty rights. The language referred to in the decision, referred to by the Baroness Margravine, relates to the contingency, which sadly has now arisen, that the United Kingdom is not present and voting in all committees and regulatory organisations of the European Union. The European Union has voluntarily decided not to exercise some of its treaty rights. Some of these organisations operate by unanimity. If there is an empty chair there, and we are a full member with full voting rights, which we have not exercised, decision-taking machinery among the European Union, which we are a member, but being exercised only by the 27, could grind to a halt. That is why that language is in the European Council decision. And that is why this government, our government, though in my view quite wrongly, it has decided to operate an empty chair policy in certain parts of the European Union organisation. It has agreed that the presidency, the Finnish presidency, shall exercise our voting rights as if we were there, so that unanimity, where it's necessary for a decision to keep the business going, can still be reached. That was the purpose of the European Council decision language. The key point here is that Article 53 is only about temporal extension. So I have to say to the Baroness Deitch, for whom I have a huge admiration, and of course she is a lawyer and I am not a lawyer, that I believe it is not possible to set conditions to the extension of time under Article 50. And therefore I have to say to her and to Baroness Faulkner of Margravine that I believe both amendments are unnecessary and should be withdrawn.
Before the noble lord sits down, could he clarify? Could he clarify as to whether it would be possible for the European Council to set the condition that the British Parliament or the British government agree to hold a referendum? I agree that it would not be possible for it to set conditions which limited our powers within the period of membership, but surely it is possible for them to do that.
absolutely out of the question. The treaty language, including in Article 50, is absolutely clear that it is for the member states to proceed under their own constitutional procedures. That is specifically spelt out, including in Article 50. The idea that the European Union would interfere in our domestic decision-taking and constitutional arrangements is out of the question.
My Lords, might I, on a slightly more pedantic level, try to assist the noble Viscount Lord Trenchard with his earlier question. I think he thought that Lord sitting days had not been statutorily defined. They are actually defined in Section 13, subsection 16. I promised pedantry. Of the European Union Withdrawal Act 2018.
I thank the noble lord for his clarification, but that does not affect my basic premise that nevertheless the bill refers to Lord's sitting days, to days and to calendar days in a confusing manner, and I think that also needs to be clarified.
Yes. My Lords, I said yesterday what a privilege it was to be in this House, but having heard both the noble and gallant Lord Stirrup, noble Lord Lisvane, not from the crossbenches but Lord Cormac, they answered the points that I really wanted to make on this amendment. And the context, the starting point for the context is, obviously, as the noble Lord Cormac said, the limitation on time, both for this House and the other House, imposed by prorogation. In circumstances where we might think theoretically about asking the Commons to think again, there will not be time. There will not be time for ping-pong, because if prorogation hits in, this bill falls. And that is the thing that this House, I believe, by pushing through, by voting for, not voting, but accepting second reading yesterday, wanted to avoid. Now let me come, and where from? Oh, I'm so sorry.
Thank the noble lord very much for allowing me to say, hasn't the noble Lord Kerr given us the answer? And doesn't it actually just simplify entirely the amendment before us?
The noble and learned lady is absolutely right about that, and that's why I particularly complimented and thanked him for his intervention and his observation. And the conditions that the noble Baroness Lady Deitch referred to, a monetary issue requiring us to have a new Prime Minister, and I forget what the third one was, it doesn't seem referendum, are not things, in my view, that the European Union could impose on this country. And though, we've said this before and I'll say it again, though the noble Lord Kerr is not a lawyer, he did draft Article 50, so he does know something about what its conditions contain. Say this also, if I may
assist the House by addressing this point, which arises out of Lord Kerr's, the noble Lord Kerr's observations. The noble Lord did indeed draft Article 50. The article is drafted in terms that do not expressly confer a right to withdraw an Article 50 notification, but it has now been held, in accordance with Lord Kerr's views, that such an entitlement, namely to withdraw the notification, impliedly exists. For myself, I do not think it is difficult to argue for an implication that it is legitimate for the European Council to seek to impose conditions to our request for yet another extension, which is a request for an indulgence. And I wonder if the noble lord would insist on that.
I beg to differ from the noble lord. Noble lords will also bear in mind that anything that the European Council does or seeks to do is itself subject to the requirements of the treaties. And if they do something which is thought to be outside the treaties, that is justiciable in the courts of this country, and we now know very well that they can do that, but also in Brussels and in Luxembourg. So I don't see a problem with that. I don't see the difficulty that is raised. The bill is clear that if we get the answer, you can have this extension to this date, the Prime Minister has to act. If the date is different, well, that's a different consideration, and that will have to be considered by the Commons. But if we were to make an amendment now to deal with something which we're being advised is not something which the European Council could do, we would be defeating this bill because we would be sending it back to the Commons, who would not be sitting to receive that amendment or able to deal with it. So I was therefore going to respectfully invite the noble Baroness to withdraw her amendment, but if she doesn't do so, certainly we will oppose it.
I am not a lawyer, but I believe from what I've heard that this amendment carries considerable weight. I'm not even persuaded by the noble Lord Kerr that conditions could not in practice be imposed. We know that that has been talked about frequently, both by leaders of our partners in Europe and by European commissioners. Are noble lords going to tell me what would happen if we asked for an extension? They'd say, what's it for? They have repeatedly asked us, what's it for? And we said, we don't know. And they said, well, then you're not going to have a referendum. We said, well, hang on, sorry, you're not going to have an extension. And if we say, well, actually, we think we're going to have a referendum, they say, all right, you can have an extension. Is the noble Lord Kerr saying that that couldn't happen? That that process of discussion and dialogue couldn't happen? It actually seems to be quite compatible with the article or section 3 of Article 50, which says the treaties shall cease to apply to the state in question from the date of entry into the force of the agreement, or failing that 2 years after the notification referred to in paragraph 2, unless the European Council, in agreement with the member state concerned, implying that there may be a range of things to be agreed about, unanimously decides to extend the period. Now, what I originally wanted to ask about was that actually this amendment raises, to my mind, a rather more fundamental question about subclause 1 of Article 3, which begins with the words, if the European Council decides to agree an extension. It can only decide by unanimity. Once it's decided, its decision is European law and binding upon us. There is therefore no possibility of coming back to the House of Commons and overruling that decision. We were told that in terms in March, where the Prime Minister went to the Council, agreed an extension, came back, the House of Commons, people in the House of Commons wanted to have a vote on it, and we were told, you can have a vote if you like, but it's law anyway. So the assurances that we've been given that the Parliament itself could overrule an agreement if or could not agree to a decision by the Council if we didn't like it, the length or any terms that might be implicit in it, is simply, as far as I understand it, not true. Now, I am not a lawyer. Those were my opening remarks. If a lawyer is prepared to stand up and say that a decision of the European Council is not binding in European law and therefore binding on us before we are left, then my objection falls. If not, I think we found a very major weakness in this bill.
It would appear that everybody in the House is toing and froing to Brussels. I better make it clear. The last time I was in Brussels, I was still a Northern Ireland minister. On the day the beef ban was lifted, I was serving Northern Ireland beef to trade delegations to rebuild the industry. But that was my last time in Brussels, so I'm not party to any of the discussions. The whole point about the amendment, which I think has been sufficiently answered in a way that much better than I could do, is built on an assumption about the unconditional extension of time. And it would actually confuse Clause 3. Clause 3 is precise in some ways, but subsection 4 gives the flexibility. It's very interesting. There's an amendment from the same group of people to knock out subsection 4. Because that gives the capacity of the Prime Minister to actually agree a different date. There is flexibility and precision built in order to achieve the objectives, because at the moment we're in an unknown area, and I think, to be honest, to add the amendment be confusing. I also would have to say that I'm not going to argue disputes with lawyers and drafters of legislation, but the fact of the matter is, I would take it from Lord Kerr on the way he explained it, and Lord Cormack on the way they explained it, over and above legalistic nitpicking of what is quite a precise clause in the bill. In fact, this is probably the best drafted clause in the bill when you look at the actual bill itself.
Did the noble Lord notice that Lord Kerr did not come back and deny that the sort of discussions I suggested could take place and would implicitly involve conditions?
Notice, I did note it, but I've no comment to make on it. Look.
I don't think it's for me to comment on discussions in the European Council, like Baroness Ludgrove. I don't know what happened when President Macron was arguing for a shorter extension in the last European Council. It is perfectly possible that there might be a dialogue with the British Prime Minister that would take place. But it is what is not possible is that there could be a conditional extension. The extension would be unconditional, because that is what the treaty says, or rather, the treaty contains no powers for imposing a conditional extension.
That being the entire point, therefore, I invite the noble Baroness to withdraw her amendment.
Lords, I think much more heavy weather has been made of this than I intended. A couple of opening comments. It's a pleasure to see the noble Lady Faulkner over here. And I have to say to the noble Lord Kerr, that those who draft law are not thereafter charged with interpreting it. Once they have launched their draft, it is over to others to interpret it. And I don't claim by any means to be a European lawyer, far from it. My point is very, very simple. If an extension is granted to the 30th of January, the Commons gets 2 days to consider it. If an extension is granted to the 31st of January, they get no time at all. I still have heard no reason or sense why that should be so. And I remain convinced that this was some sort of drafting oversight. Not to mention 2 days, no one's clarified that, sitting days, calendar days. What if an offer comes at the weekend, during the Christmas recess, or sometime when we're not here? So I think since the lawyers themselves, both the noble and learned lords in this House, and those who are clearly just as learned but are mere QCs, have different opinions about this, it is quite possible that something that is a bit tricky may come our way at a time when we're not sitting, or may come our way when the Act provides no 2-day pause for the Commons. So either the Commons should have 2 days to consider anything, or it shouldn't have 2 days at all. I've heard no logical answer to that. I sense that it is the will of the House that I withdraw this now. But before report stage, I would expect to hear some sense from someone. I don't know who gave the draftsmen their orders. I haven't yet heard a sensible reason why an extension to the 30th of January gets 2 days consideration and to the 31st it doesn't.
Can I just try maybe and give an explanation? It is because the terms of Clause 3.1 specifically says 11 p.m. on the 31st of January 2020, and that would have been passed, by definition, that will have been passed by the House of Commons, as indeed it did on Wednesday of this week. Therefore, they don't really need 2 days to agree something they've already agreed to and put in statute.
I understand that point, but given that there has been disagreement, enough to worry me, about what the European Union might say, others who know much more than I do have expressed opinions of different sorts, and we're left with this 2-day definition. Nobody knows what it means. I think there is a real legal problem there. I don't know who drafted it. I don't know who gave the orders. We haven't really heard a logical answer. For now, I withdraw, with your leave, but I would expect someone to give a proper explanation at some stage during the course of the discussion, because we're in a bit of a legal pickle over that particular clause.
Is it your Lordship's pleasure this amendment be withdrawn? No. I therefore have to put the question on Amendment 2. The question is that Amendment 2 be agreed to. As many as are of that opinion will say content. As many as are of that opinion will say content. The contrary, not content. Not content. The not contents have it. Also in clause 3, also in Amendment 3, in clause 3, Amendment 3, Baroness Faulkner of Margravine, not moved. Amendment 4, Baroness Neville-Rolfe.
The House rightly scrutinises bills that come from the Commons, including private members' bill like this one. Right. My Lords, I apologise for my late arrival today. I moved a time-critical meeting very early, and then I got afflicted by the transport delay. Circumstances can upset timing, as we all know from our debates on these bills. Now, as my noble friend Lord Forsyth said, we have a duty in Parliament, and this House plays a key role, wherever we come from, to make clear that legislation works. Otherwise, I fear we will be held up to contempt in this country. They look upon us already with increasing incredulity, and that is a big concern. I just hope that the noble Lord Kerr is right on Amendment 2. Now, this is a committee stage, and my amendment, my Lords, is a probing amendment. I gave notice of my concern at second reading, and the noble Lord Rooker has only half answered my question. I am concerned that subsections 1 to 3 tie the government's hands too tightly and put UK interests in jeopardy, whatever the motivation for this bill, which was, of course, agreed in the other place. Please.
Order.
I do not understand, I will be brief, what subsection 4 does and how it interrelates with the rest of clause 3, or indeed the rest of the bill, and the sponsor's game plan for our relations with the EU once this bill becomes an act. I would also be keen, like others, to hear what is happening to the Kinnock Amendment, which the Minister explained yesterday to be defective. I beg to move.
Amendment proposed, page 3, line 21, leave out subsection 4.
This was a provision which was put into the Cooper-Letwin bill very much at the insistence of the government at the time. And the reason, no, I'm not trying to make a point against the government. The reason for it, and that's why I say it was from the government, was to preserve the prerogative of the government to be able to accept an amendment. At that stage it was thought it's possible that the European Council will offer an extension at a council meeting. Are you saying that the Prime Minister will not be able to accept it? And after consideration of that, it was put into the bill, into the Cooper-Letwin bill, that the Prime Minister should in fact be able to accept. Now what this does in this bill, in 3.4, is to say again, nothing will prevent the Prime Minister from agreeing to an extension, doesn't allow him to refuse an extension, but from agreeing to an extension of the period specified, otherwise in accordance with this section. So he doesn't have to go to the procedures if he wants to accept it. Now that is a way of preserving the prerogative of the privilege of the government to make agreements at an international level, but on that specific basis. So that's the reason for it. It's appropriate to have it in this bill too. The time for it actually to arise is limited, and I think if I understand correctly what Mr. Johnson has said about ditches, there's going to be no question of his agreeing to anything unless he's constrained by this bill. So it's an interesting question, but I think it's entirely academic. So in those circumstances, I hope that answers the noble lady's question, and we can move to complete committee.
Before he sits down, I wonder whether the noble lord could explain whether the Prime Minister, in a meeting faced with that question of a change along those lines, if there were conditions placed upon it in that meeting of the Council, how does this subclause address that possibility?
Given what the Prime Minister said, this is not going to happen. But the prerogative of the Prime Minister is retained under this provision, as it is in the other bill.
This is simply keeping free from constraint the prerogative of the Prime Minister, notwithstanding this bill. This bill simply deals with requiring the Prime Minister to apply for an extension. If he manages to get one anyway, that doesn't matter, and that's what's preserved. And there's no question at that stage, if you accept Lord Kerr's proposition about the nature of extensions, there's no question about conditions except temporal conditions. And therefore, what the Prime Minister here is allowed to do is what, apart from this bill, he'd be able to do, and this bill is an additional requirement on the Prime Minister when it's activated.
Can I just ask the House for forbearance and make quite sure that everybody on all sides is entirely in agreement that this extension, which the bill demands the Prime Minister seeks, is for one purpose only. Look at the Kinnock Amendment, the second part of Clause 1.4, and that is to try, and heaven knows I strongly support this, to get something like the May deal finally agreed, which I've long suggested it should be. But it would be quite unlawful, having got such an extension, for anybody then to say, but we must actually instead use it to retract Article 50 notice or to seek for a referendum or anything like that. We're all happy and agreed, are we, on that?
No. I want to be clear about that. There's certainly no commitment coming from this bench, these benches, that that's what the bill requires. If it's passed into law, it contains those words, but it does not constrain what the extension is used for.
My Lords, there's not much for me to say, although I alluded to this in the previous debate, the fact that Clause 3 is quite precisely drafted and subsection 4 is there to give the flexibility if other circumstances prevail. I'd forgotten about the Cooper-Letwin bill, having started off that myself in April, as to where it came from. In other words, it came from the current government on strike. So please put it in your bill. So we're happy to agree to the government's original plan to have it in the bill. Therefore, the noble lady did say it was a probing amendment, and I'll be very happy, therefore, if she withdraw it.
I'm grateful for the advice on all sides, good legal advice as to what this provision means. It's obviously a helpful provision, and I'm certainly not going to... I'm happy to withdraw my amendment. My concern is that this is an act without an end date, and so it is right to make sure that we understand the provisions and how they would work for the future. I beg to leave to withdraw my amendment.
Yeah. Is it your Lordship's pleasure this amendment be withdrawn? The amendment is by withdrawn. The question is that Clause 3 stand part of the bill. As many as are of that opinion will say content. Yes. The contrary not content. The contents have it. The question is that Clauses 4 and 5 stand part of the bill. As many as are of that opinion will say content. Yes. The contrary not content. The contents have it. The question is that this be the title of the bill. Oh, it's schedule. The question is, that's why. The question is that this be the schedule to the bill. As many... I just want to say something
about that. This is the print of the letter that the Prime Minister is required to send under the bill. And if there had been time, I would have proposed that the letter includes the reason, because after all, it's to the European Union that the reason is to be expressed. because as I understand it, the European Union say that if they're going to grant an extension, or are asked to grant an extension, they wish to have the reason. And therefore, in the ordinary course of events, it would be right to have the reason in the letter. Unfortunately, the time prevents that from happening. And therefore, I just want to say that it would have been better, but I'm sure that, what should I say, the initiative will be sufficient for the reason to be communicated to the European Union, even although it's not stipulated for in the letter, although the actual terms of the bill really say this is the letter. And so adding to it may have a certain amount of risk, but it may be a risk that properly should be taken. My Lord, so far as the noble and learned Lord's question about what this means is concerned, this is...
If he's arguing that the letter has got to have a reason in it, doesn't that mean that it's conditional?
No. It isn't. It is the condition that is obvious to give a reason why you have to apply for an extension, or why you're applying for an extension, because the time point is, as Lord Kerr says, the important point, and they want to know how this time is to be taken up. That's the idea, and it seems to me to be perfectly sensible.
Obviously, he's far smarter at this than I am, but the noble Lord Kerr argued that it was not possible for any conditions to be applied. So why is it necessary for us to give a reason?
It seems to me to be obvious. If you're asked to make an extension, you don't just do it for the sake of doing it. You have some reason for it. And I don't think the European Union, far as it may be from common sense in many respects, for all I know, I don't think it's so daft that it provides for an extension to be applied for with no reason on earth why it should be granted. It seems to me to be common sense that the reason is required. And of course, the bill contains the reason, but just hasn't happened to put it in the letter. I suspect that perhaps what happened was a copying of the Cooper, the previous bill, and it didn't have the reason in it at all, as I pointed out at the time. So this bill is much better. It has got the reason in. Unfortunately, not so good that it has it in the letter as well. But as I say, I don't think that matters. So far, at least I don't think ultimately it will matter. So far as my noble friend, the noble and learned friend's question about the reason, I think it is quite important that the reason which is given in the bill is the reason which has to be given in support of the application for the amendment. And that I would certainly have suggested it goes in the letter if there had been time, but I appreciate fully that there isn't time, and therefore we must leave it as it is.
My Lords, besides what my noble and learned friend has just said about the letter and its deficiency in not including a reason, do your Lordships not think it would be much better if it also made clear what the parties are supposed to ratify? It simply says if the parties are able to ratify before this date, but there is no object of the sentence, there's no object of ratify. It's clear it refers to a withdrawal agreement. I can understand that. But I think that it's very sloppy drafting, and it could be argued that it referred to the ratification of something else.
Responding to Lord Mackay, we spoke outside the chamber last night because he raised this right at the end. I mean, he's got a very valid point. But the bill, as it is still sufficient, and we are under the prorogation guillotine. If we weren't, then we would have some flexibility. It's the prorogation guillotine has removed the flexibility from the House to deal with that.
I apologise for forgetting the letter. The question is that this be the schedule to the bill. As many as are of that opinion will say content. The contrary not content. The contents have it. The question is that this be the title of the bill. As many as are of that opinion will say content. The contrary not content. The contents have it. My Lords, that concludes the committee's proceedings. The House will now resume. My Lords, the Committee of the Whole House, to which the European Union Withdrawal No. 6 Bill was committed, has gone through the same and has directed me to report it to your Lordships without amendment.
My Lords, the House will now adjourn to allow for amendments to be tabled for report stage. The Public Bill Office will be open to receive amendments for the next 30 minutes. The House will then resume as soon after that as possible, and timings will be displayed on the annunciator.
The question is that the House adjourn during pleasure. As many as are of that opinion will say content. The contrary, not content. The contents have it.